How you doing? I'm your anchor, Phil Marson, aka Seymour Butts, and this is Channel 8 News, WPHIL. Coming up on tonight's broadcast, is the government putting chemicals in the water to turn frogs gay? Ballerinas, are they the most masculine of us all? Tuna, they call it the chicken of the sea, but is there really any chicken in there? But first, Lawrence v. Texas, the controversial Supreme Court case dealing with intrigue and sodomy. Over to Chris with your briefing today.
On September 17, 1998, the Houston police responded to a weapons disturbance in a private residence that was called in by Robert Eubanks. They entered John Lawrence's apartment with their weapons drawn. Upon entrance, they found Lawrence engaging in private consensual sexual act with another male, his partner, Tyron Gardner. The Houston police arrested them and convicted them of deviant sexual intercourse. This was due to a Texas statute forbidding same-sex intimate contact. The State Court of Appeals found that the statute was not unconstitutional under the Due Process Clause of the 14th Amendment, and also citing Bowers v. Hardwick, where Michael Hardwick was seen committing a similar act in his home. At Lawrence and Gardner's hearing the next day, they pled not guilty to homosexual conduct. The judge found them guilty and fined them both $100. Eubanks was sentenced to 30 days in jail for filing a false police report. Now down to Nathan with some personal interviews.
Hi guys, thanks for that lively update of the facts. My name is Nathan Hill and I'm a field reporter with WPHIL, where if it looks like it's being shot on an iPhone, it probably is. I'm outside the Supreme Court of the United States today trying to bring facts to you about Lawrence v. Texas before we get a breaking news update with the decision. First, I spoke to a representative from the Lambda Legal Defense and Education Fund, and while they did not give me permission to film them on camera, they did give me permission to bring you the information that they told me. First, they would like me to tell you a little bit more about the Lambda Legal Defense and Education Fund. They were founded in 1973, and they are the oldest and largest national organization whose mission is to achieve full recognition of civil rights of lesbians, gay men, bisexuals, and transgender people, as well as everyone living with HIV through impact litigation, education, and policy work. They are a national organization dedicated to gay rights, and they are the organization that took up Lawrence's case and appealed it through the entire Texas court system on the grounds that it violated the Equal Protection Clause of the 14th Amendment. So, the Lambda Legal Defense and Education Fund asked the Supreme Court of the United States to review three things. First, they were wondering if the criminal convictions of Lawrence under the Texas homosexual conduct law violated the 14th Amendment guarantee of equal protection of laws. Second, they asked, do their criminal convictions for adult consensual intimacy in the home violate their interest in liberty and privacy protected by the 14th Amendment Due Process Clause? And finally, they asked the court if Bowers v. Hardwick should be overturned. Bowers v. Hardwick is the precedent used in most cases like these. It was decided in 1986, where the justices agreed in a 5-4 majority that there is no constitutional protections for cases of sodomy. So, we are waiting outside the Supreme Court with thousands of citizens who are waiting to hear what the Supreme Court has to say, and when we do, we'll be the first to break it to you. Again, I'm Nathan Hill with WPHIL, brought to you by Polo Shirts. Back to you guys.
Thank you, Chris. In continuing with the story, the gay rights advocates from Lambda Legal litigating the case convinced Lawrence and Gardner not to contest the charges and to plead no contest instead. On November 20th, Lawrence and Gardner pleaded no contest to the charges and waived their right to trial. To appeal, Lawrence and Gardner needed to have their cases tried in Harris County Criminal Court. Their attorneys asked the court to dismiss the charges against them on the 14th Amendment equal protection grounds, claiming that the law was unconstitutional since it prohibited sodomy between same-sex couples, but not between heterosexual couples. They also asserted a right to privacy, and the Supreme Court's decision in Bowers v. Hardwick that found no privacy protection for consensual sex between homosexuals was wrongly denied. On December 22nd, Judge Sherman Ross denied the defense motion to dismiss. A 3-judge panel of the Texas 14th Court of Appeals heard the case on November 3, 1999. Their 2-1 decision issued on June 8, 2000 ruled the Texas law was unconstitutional. Justice John S. Anderson and Chief Justice Paul Murphy found that the law violated the 1972 Equal Protections Amendment to the Texas Constitution, which bars discrimination based on sex, race, color, creed, or national origin. J. Harvey Hudson dissented. After a year's delay on April 17, 2002, that request for appeal was denied. Lambda Legal's Harlow called that decision a major abdication of judicial responsibility. Bill Delmore, the Harris County prosecutor who argued the case, called the judges big chickens and said they have a history of avoiding the hot potato cases if they can. A petition for certiorari was filed in the U.S. Supreme Court on July 16, 2002. Lambda Legal attorneys asked the court to consider whether petitioners' criminal convictions under the Texas homosexual conduct law, which criminalizes sexual intimacy by same-sex couples, but not identical behavior by different sex couples, violates the 14th Amendment. Whether the petitioner's criminal convictions for adult consensual sexual intimacy in their home violate their vital interests in liberty and privacy protected by the Due Process Clause of the 14th Amendment, and whether Bowers v. Hardwick should be overruled. On December 2, 2002, the court agreed to hear their case. Lambda Legal coordinated the submission of 16 amicus curiae briefs to complement their own brief. Submitting organizations included the American Bar Association, the American Psychological Society, the American Public Health Association, the Cato Institute, the Log Cabin Republicans, a group of history professors, and a group of religious denominations. At oral arguments in the Supreme Court, on March 22, 2003, Paul M. Smith, an experienced litigator who had argued 8 cases before the Supreme Court, spoke on behalf of the plaintiffs. Texas Attorney General John Cornyn, then a candidate for U.S. Senate, refused to have his office argue the case. Charles A. Rosenthal, District Attorney of Harris County, represented the state in this case. His performance was later described as the worst oral argument in years, but many believe his lack of preparation reflected his lack of enthusiasm for the state he was defending.
Thanks, guys. Me, Nathan Hill again, field reporter for WPHIL. Just received word from one of my sources within the Supreme Court of the United States that they believe that the decision is going to go in a 6-3 majority towards Lawrence. And while we do not know what their reasoning may be in deciding for Lawrence, we will hear word of that very soon. The only 3 people that are dissenting appear to be Rehnquist, Scalia, and Thomas. So in other words, shocking news. Back to you guys. I hear we have some breaking news on the decision from the Supreme Court of the United States.
Yes, breaking news. The Supreme Court released its 6-3 decision, striking down the Texas statute. 5 justices held it violated due process guarantees, and a 6th, Sandra Day O'Connor, held it violated equal protection guarantees. The 5-member majority opinion overruled Bowers v. Hardwick and implicitly invalidated similar sodomy statutes in 13 other states. Justice Kennedy wrote, "The petitioners, Lawrence and Gardner, are entitled to respect for their private lives. The state cannot demean their existence or control their destiny by making their private sexual conduct a crime." Now, over to our constitutional analysts who are here to argue and debate this controversial ruling. Over to you.
Overturned 1986 decision of Bowers v. Hardwick, which stated the state of Georgia had a right to outlaw anal sex between same-sex couples. This was overturned on the basis that it violated the right to privacy and the Equal Protection Clause. According to Justice Kennedy, who wrote the opinion of the court, prohibiting this act has far-reaching consequences that would allow for states to restrict other aspects of people's home lives, which is unconstitutional and violates precedent. Sex is an expression of love in a romantic relationship, and that is protected by the Constitution. The Texan law violates the Equal Protection Clause because it exclusively bans homosexual couples from engaging in this act. It demeans same-sex couples just as it would opposite-sex couples. Kennedy also states that the Bowers decision, when made, claimed historical precedent when there had previously been none. Most sodomy laws in the United States were not enforced in this manner and mostly existed to catch rapists and child predators. It wasn't until the late mid-1900s that they began to be used to discriminate against homosexuals. The cultural tradition does not hold up much ground either, because recently the European Union declared similar laws discriminatory. Furthermore, cultural and historical tradition does not make something constitutional. According to the Supreme Court, the previous decision was fundamentally wrong, which is why it has been overturned.
On a dissenting opinion, Justice Scalia wrote, joined by Chief Justice Rehnquist and Justice Thomas. Nowhere in this court's opinion does it declare that homosexual sodomy is a fundamental right under the Due Process Clause, nor does it subject Texas law to the standard of review, which is reviewing a decision of a lower court. That would be appropriate if homosexual sodomy was a fundamental right. The respondent is asking us to announce a fundamental right to engage in homosexual sodomy, which we are quite unwilling to do.
Hold on. Homosexual sodomy is a fundamental right in that sex falls under the protection of the right to privacy. This comes from Griswold v. Connecticut and, by extension, the Constitution. This right comes from a combination of the First, Third, Fourth, Ninth, and 14th Amendments. The combination of the freedom of speech, prohibition of soldiers being quartered in civilian houses during peacetime, the right to being protected from unwarranted search and seizure, that rights should not be construed to deny rights to other people, and the Equal Protection Clause create the right to privacy. The government cannot regulate trivial aspects of people's lives, such as homosexual sodomy, because it is not relevant to them, and they do not have the right to invade it.
Okay, if you're saying that you can't invade it because it's a privacy right, so does the privacy right mean in your own home? The fact that the laws were not enforced for acting in private sodomy, consensual sodomy like heterosexual intercourse is rarely performed on stage. If all the court means by acting in private is that it's on the private property with closed doors and covered windows, it would be very hard to get a search warrant for a residence on the grounds of probable cause that there was consensual sodomy going on right then and there. We don't change our laws because other nations just decriminalize the conduct, as this court believes. Justice Bowers, in his Bowers dissent, said the fact that a governing majority in a state has traditionally viewed a particular practice as immoral is not a sufficient reason for upholding a law prohibiting the practice.
As stated in that opinion, the law was not easy to enforce and had little effect. And by a utilitarian standpoint, if a law does not work, there's no reason to bother keeping it. And furthermore, Justice Kennedy cited the European Union in his opinion because it was relevant to striking down the notion that this law was just from a cultural, moral standpoint, that this had a cultural history. European history has cultural influence on the United States.
But we don't make our laws based on what other countries do.
No,
we base our laws on what the people in the United States want to do. And there are 50 states right now that have, there are 50 states right now, 50 out of the 50 states, there are 24 states that have laws outlawing sodomy, and the District of Columbia. They have criminal penalties for sodomy performed in private and between consenting adults. So if we have 24 states plus the District of Columbia saying that it's against the law to do this, then what right is it for them to say that they have to change that because European laws changed?
No.
We don't change our laws for that.
They do not have the right to keep those laws because it invades certain people, a minority group's privacy.
Okay,
It
so
infringes
if-
their rights.
But if they get rid of this, if Bowers is struck down, that is making state laws against bigamy, same-sex marriage, adult incest, prostitution, masturbation, adultery, fornication, bestiality, and obscenity are all sustainable only in the light of Bowers' validation of laws based on moral choices. Every one of these laws are brought into question by today's decision. The impossibility to distinguish homosexuality from other moral offenses is why Bowers rejected the rational basis challenge.
Well, it is possible that we can find a way around this because we do not need to make laws of regulating people's sex life based on moral reasons. What we need to make laws for is about demonstrable harm. So, with specifically bestiality, incest, and child pornography, those acts do cause demonstrable harm.
And none of the
Bestiality-
other ones don't?
No, not any.
None of
real
the other ones
offenses.
don't. Even opposite sex marriage, opposite sex, heterosexual sex is a demonstrable health risk if you don't wear a condom. So how do you say that bestiality or any of the other ones that they do face health problems? If you have sex, if it's not safe sex, there's a chance that you could get a sexually transmitted disease. So you can't argue that.
With bestiality, you can create new diseases.
Like HIV
Yeah, that is a new
And AIDS.
disease.
HIV and AIDS, but it's the same way they get it in sodomy.
Yeah, that is true, but in most cases, sex is safe and you can make it safer. But regulating that invades privacy.
So let's go to the prostitution. That makes this, by eliminating or getting rid of the Bowers case, that would make prostitution legal.
There are movements to
And
make prostitution legal.
if I
because
want to buy a house,
prostitution
if you want to buy a house and get 5 girls to rent 5 rooms off of you, they're renting that house. That's their private property that they're renting. They can do prostitution in the home that they rent, and that's a privacy in their home.
There are movements to make prostitution legal because if you think about it,
But is that really what our country wants? Is that the kind of country we want to be?
Is there a problem with it outside of moral reasons? You could argue that
There is. Because you know what? That also
you could-
causes demonstrable health risks.
You could argue having it legal protects people in that industry more. It could protect, like having it legal would allow for prostitutes to actually gain
It would
health.
allow more for
If
human
they-
trafficking. That's all it would allow for.
It could actually prevent human trafficking because many sex slaves can often cannot get help because they have criminal records because they are forced into prostitution and they are arrested instead of getting help.
I'm just saying that this is going to be a massive disruption in the current social order the overruling of Bowers entails.
It could
But not so in Roe, which would Roe versus Wade, if they overruled that, all that would do is give the rights back to the states to determine the restrictions and possibility of an abortion. And they won't do that.
Well,
But they
We
want to
should
take
always
away
have federal
they want to
laws
take
and
away all
state.
the states' rights and give it to 9 people who are appointed by the president and take all the rights from all the elected people in our states and give it to the 9 people in the Justice Department.
they already had that power back in the 1800s.
Yeah,
from
well
the
then we
Marbury
need to
versus
change that.
Madison
Then we need to
decision.
get that changed. If they can take all the power away from the legislators from all the states and give it to the judicial system in the Supreme Court and give 9 people, which 6 in this case said that this is okay to do.
That is a super
So
majority.
you got 6 people. You got 6 people out of all the people in the United States saying that this is okay. So this makes us a good law.
I believe it does. They decide what is constitutional, and they also can decide whether it's not constitutional. But this...
Countless judicial decisions and legislative enactments have relied on ancient proposition that a governing majority belief that certain sexual behavior is immoral and unacceptable constitutes a rational basis for regulation. And that's what we have been doing for years.
Reason to regulate something, and something being traditional and historical does not make it right or constitutional or valid in the modern age.
Okay, I want to bring up something else that you talked about, and that was the Equal Protection Challenge.
Okay.
The Equal Protection Challenge, no member of this court except O'Connor embraces the Texas state law 21.06. Applies equally to all persons, men and women, homosexual and heterosexual. All are subject to this prohibition of deviant sexual intercourse with someone of the same sex. This is not a denial of equal protection under the law. It is precisely the same distinction for everyone.
You could argue that it is in merely the words, but in practice it does discriminate against homosexual men in particular, because like for one, it does not apply to anal sex between opposite sex partners. If it did, then that would be non-discriminatory.
It does.
But homosexual men are, but more importantly,
it does. It includes everybody, not just them. It includes everybody.
It includes everybody in that they aren't allowed to do it in same-sex relations. It does not mention doing it with opposite-sex relations. You can have...
It does. It states between homosexuals or heterosexuals.
No,
all are subject to its prohibition.
Anal sex with opposite-sex partners.
But the thing is, if it's all done in private, who's going to do anything about it?
Oh, that's what
End
makes
of the
the
argument.
law stupid.
End of the argument.
What a riveting discussion between our analysts. You'll truly never get TV like this, folks. Now, over to our In the Field correspondent, Nathan, who's been conducting some interviews to see just how the public feels about this ruling.
Welcome back to WPHIL News Station. I am Nathan Hill, and I am outside the Supreme Court of the United States, where we just heard the news that the Supreme Court ruled in majority that the Texas state sodomy law furthered no legitimate state interest that justified this intrusion on the citizens of Texas, rendering the law unconstitutional under the Equal Protection Clause of the 14th Amendment. I have been out here talking to citizens who are crying and overjoyed with the decision that the Supreme Court has come to. One individual went ahead and said that he hopes this paves the way for gay rights in this country, hopefully implying that this means the court is more willing to examine the rights of same-sex couples within the United States. Another individual went as far to say that this proves that the Supreme Court of the United States sees gays and lesbians as ordinary people. And one final individual that I spoke to hopes that this means that the United States will become more tolerant of same-sex couples within the United States. While we will not know the far-reaching effects of this court decision for at least months to come, what we do know is that this is a win for same-sex couples within the United States. Back to you guys in the station. Again, I'm Nathan Hill with WPHIL, where we only drink out of one coffee cup.
In conclusion, the Supreme Court has decided to rule in this way, and while it may be controversial, they feel that they have not only upheld the state's rights, but also the rights of the individual. Thank you for tuning in to WPHIL Channel 8. I have been your host, Phil, and also known as Seymour Butts. Thank you for tuning in, and we hope to see you tomorrow at 8. Bum, 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 bum. Bum, 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 bum.